Many couples in Iowa seeking a divorce face unfamiliar terms and issues regarding their dissolution of marriage. Understanding the process will help you as you navigate an emotional situation. The Iowa State Bar Association has created this video to provide you with information about issues and terms involved in a dissolution of marriage. It is not an attempt to provide legal advice, and in fact the ISBA would encourage you to consult with your attorney regarding your case to ensure your rights and interests are protected. The first question generally asked is, where do I file for a dissolution of marriage, and do I need to live in Iowa? If the respondent spouse or opposing party is a resident of Iowa and was personally served the dissolution of marriage papers, there is no residency requirement for the spouse who files the dissolution of marriage. Otherwise, there is a 1-year residency requirement, meaning you must have lived in Iowa for 1 year. In addition, there is a 90-day waiting period before the dissolution of marriage may be finalized. This time period starts when the case is filed. The dissolution of marriage may be filed in a county where either spouse resides. In Iowa, what are the legal grounds for dissolution of marriage? The only grounds are defined as the breakdown of the marriage relationship to the extent that the legitimate objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. No fault is needed to obtain a dissolution of marriage. You may seek a legal separation in Iowa. If the respondent spouse is a resident of Iowa and was personally served legal papers, there is no residency requirement for the spouse filing for a legal separation. Otherwise, there is a 1-year residency requirement. The grounds for legal separation in Iowa are the same as for a dissolution of marriage. That is, that there has been a breakdown of the marriage relationship to the extent that the legitimate objects of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. There may be mediation or counseling requirements as part of the dissolution proceeding. If either spouse requests, or on the court's own initiative, the spouses may be ordered to participate in conciliation procedures for a period of 60 days. A course on children's needs is required for all parents when custody is at issue within 45 days of the commencement of the case. The distribution of property is a critical part of a dissolution proceeding. Iowa is an equitable distribution state. The court will divide all the spouse's property whether it was acquired before or after the marriage. The exception to this is any gifts and inheritance received prior to or during the marriage. A portion of the property may be set aside in a fund for the support, maintenance, and education of any minor children. Marital fault is not a factor. The following factors are considered in division of property: the contribution of each spouse to the acquisition of the marital property, including the contribution of each spouse as homemaker or in child care, the value of any property brought to the marriage, the contribution by one party to the education, training, or increased earning capacity of the other, the length of the marriage, the age and physical and emotional health of the spouses, the vocational skills of the spouses, the time and expense necessary to acquire skills and training to become self-sufficient, the federal income tax consequences of the court's division of the property, the time and expense necessary for a spouse to acquire sufficient education to enable the spouse to find appropriate employment, any premarital or marital settlement agreement, the present and potential earning capability of each spouse, including educational background, training, employment skills, work experience, and length of absence from the job market, whether the property award is instead of or in addition to alimony, and the amount and duration of any such alimony award, the total economic circumstances of the spouses, including any pension benefits, the desirability of awarding the family home to the spouse with custody of any children, any custodial provisions for the children, and the amount and duration of any maintenance payments. In some cases, alimony, maintenance, and spousal support is awarded as part of a dissolution proceeding. Maintenance may be granted to either spouse for a limited or indefinite time based on the following factors: the time necessary to acquire sufficient education and training to enable the spouse to find appropriate employment and become self-supporting, the duration of the marriage, the financial resources of the spouse seeking alimony, including marital property, apportioned to each spouse and such spouse's ability to meet his or her needs independently, the tax consequences to each spouse, the age of the spouses, the physical and emotional conditions of the spouses, the work experience and length of absence from the job market of the spouse seeking alimony, the vocational skills and employability of the spouse seeking support in alimony, the probable duration of the need of the spouse seeking support in alimony, custodial and child support responsibilities, the educational level of each spouse at the time of the marriage and at the time the action for support is commenced, any premarital or other agreements, the earning capacity of the spouse seeking maintenance, including the educational background, employment skills, and work experience, and any other factors the court deems just and equitable. Marital misconduct is not a factor. Maintenance payments may be ordered to be paid through the court. What is the requirement regarding the spouse's name? Upon dissolution of marriage, either spouse may request to change his or her name to a former or maiden name. Many of the couples in Iowa who seek a divorce will have minor children. Because the well-being of children depends on the quality of their relationship with both parents, it is important that parents understand the legal terms, laws, and court orders regarding their children. The courts play an important role in assisting with the future living arrangements for children. Joint or sole custody may be awarded in the interest of the children and in a manner which will encourage the parents to share the rights and responsibilities of raising the child. Joint custody may be awarded if either parent requests and if it is in the best interest of the child, and based on the following factors: the ability of the parents to cooperate, the ability to support the child's relationship with the other parent, the physical proximity of the parents to each other, the fitness and suitability of the parents, the reasonable preference of the child, if the court deems the child to be of sufficient intelligence, understanding, and experience to express a preference, whether both parents have actively cared for the child before and since the separation, whether the psychological and emotional needs and development of the child will suffer because of lack of contact with both parents, whether the safety of the child will be jeopardized by an award of joint custody or unsupervised visitation, whether one or both parents agree to or are opposed to joint custody, and any history of domestic abuse. The court may grant joint custody even when both parents do not agree to joint custody. Child support can also be ordered by the court. Either or both parents may be ordered to pay a reasonable and necessary amount of child support. Child support payments may be ordered to be paid directly to the court. Specific child support guideline charts are available on the Iowa Court's website. The amount of child support is determined by use of the guideline charts, but may be adjusted for fairness or special needs of the child. As was pointed out at the start of this presentation, if you have any questions about dissolution of marriage, the ISBA would encourage you to consult with your attorney so that you can ensure that your rights and interests are protected. If you're uncertain of your legal rights regarding divorce, a lawyer can help you assess your case. We hope this video has provided you with some helpful tips regarding issues surrounding dissolution of marriage. Thank you.